trialacademy.org, and we will make sure you get credit. All right, that's it from me. I am going to turn it over to our presenters for today's course. They are going to introduce themselves once they actually get started. Suann, you want to share your screen? Perfect. You're off to the races.
Thank you, Michelle. We are assuming that the people coming here today have cases in mind that they know very well. And so we're trying to come up with ways to get you to think creatively about communicating those case details to people who really know nothing about it. And I find Charli and I both find ourselves dealing with attorneys who know their cases inside and out, and we're faced with teaching them how to see their case with new eyes. And you've often heard the saying, a picture's worth 1,000 words, and people try to come up with the best picture. And I'm trying there. The one thing that people forget when they hear, oh, a picture's worth 1,000 words, just find the right picture, is that they have to craft those 1,000 words. And in doing that, we find, and you'll hear some of this today, we find that if people think visually and pen to paper, like try to get back to basics, that those 1,000 words will then help you find the right picture. And then we're really hoping to give you a peek through the keyhole of the process of getting the right picture.
Now, how do we know that a picture is indeed worth 1,000 words, or that maybe even an entire case can be summed up in a single drawing or a single photo or a single document? My research for 30 years with mock jurors has included an idea that a young, talented graphic designer named Kirby Dial, who worked with me at a firm in Chicago, came up with while we worked together then back in the early 90s. And Kirby's graphic design idea was to ask all of the mock jurors at the end of the trial to just try to summarize an entire case on a single side of a blank sheet of paper. And I've been doing that with Kirby's good idea for more than 30 years now. He's no longer a graphic designer in legal business, but I'm still using his excellent idea. And what we're going to share with you is a series of drawings from a variety of case types, because we recognize that with 600 different lawyers on this webinar, you've all got a variety of case types. And I want to show you how often true it is that you would ask total strangers to sum up an entire case on a single side of one sheet of paper, and they can all do it. Some of them are terrified of the exercise. Some of them will criticize their own artistic skills, but every single one of them has to do it in order to get paid by me. And so they all turn something in. And I have a pretty big library of what I call the juror cartoons. In this case, for example, 7 different plaintiffs are depicted in the lower left hand of that picture, and they are all flipping the bird to the company that terminated them. And they start to attribute the words and thoughts and feelings of the company itself to the building that they've drawn. We can go to the next one. The next one is actually chilling, because this comes from mock trials that I conducted with a colleague last year. This particular picture came out of a research exercise in the fall. As you can see, the title on the picture is Green-Eyed Monster versus Green-Eyed Monster, Stomping on the Healthcare System. And this was actually a case between insurance companies and healthcare providers. And I got this picture just months before an insurance company CEO was murdered on the streets of Manhattan. So to say that this picture would summarize the collective point of view that people will bring to a case involving insurance questions or healthcare issues is an understatement. The visceral reaction that people had to the facts and the witnesses and the arguments and even the lawyers in this case is depicted in this picture. Let's go to the next. I picked this next one because although it's hard to read and it may be hard for you to tell unless you zoom in, this was actually a medical malpractice case. And this particular juror, when he or she was asked, what is this case all about to you, actually drew a picture of a contract case, where she depicted that the relationship between the doctor and a patient was a contract for surgery. And then because there was a bad outcome for the patient and a lawsuit had been filed, she also depicted the sad, angry face of the plaintiff or the patient after the doctor says, you signed it. Now, theoretically, this is probably has something to do with the informed consent that was part of the defense in this med-mal case. The idea that every patient who goes in for surgery agrees to accept and tolerate the risks of possible complications. But this tells you that what sounds like kind of an ordinary medical malpractice case might be reframed in our imaginations as a breach of social contract. What do we expect from our doctors, and what can patients do about it when we don't have a good outcome?
And Charli, these sketches, they changed the way your clients decided to present, correct?
In some cases they do, in some cases they don't. I mean, we get 30 of these at a shot, and so I just picked the best examples that illustrate sort of the thought-provoking images that people will draw when you ask them to summarize a case in a single page. And this is very much in keeping with what you're going to talk about later, Suann, the power of taking real pen to real paper and letting those thoughts flow from our brains into our hands and onto the page is a critical first step. I can't tell you that we would have necessarily designed a graphic like this one for that trial, but go to the next one and I'll give you an example of what comes to mind. This is one of my most recent juror cartoons, and in it, a juror depicts the big bad company holding a fistful of dollars, which is often the case in the drawings that I get, reigning over a class of plaintiffs. Now, it doesn't really matter what the case was about or what the allegations were, but a good, talented graphic designer like Suann, who sees a picture like this coming out of mock trial research before a trial, might just take sort of the ominous nature of this picture on behalf of plaintiffs and use it for the color palette that she chooses to depict all of the defendants, all of the exhibits that she might create to depict the defendant's actions. So I don't know exactly what a Suann would do with this picture. I can't draw a straight line with a ruler, but when I get these pictures and then I sit down with a Suann and we get ready with a client to go to trial, these graphic images, these words and pictures that people put together on a single side of one sheet of paper can be very powerful instructions on what the story of our case should be if it isn't already.
Yeah,
I'm sorry.
I think I've seen that happen when they're drawing and you think they understand something and they could be way off, but it helps the presenting attorney decide how they're going to craft their 1,000 words.
It is exactly an opportunity to see your case with new eyes. In the next photo, I can tell you that we had actually told jurors in this case on behalf of defendants that the roadway itself would be the key witness in the case, that there would be physical forensic evidence collected at the scene that would stand in as a key witness in the case, and that jurors would have to decide based on that evidence whether the bus driver suffered a sudden medical emergency or fell asleep behind the wheel. And so to get this picture back from a juror tells us we have exactly the right words, phrases, and ideas in mind for our case. When we tell people from the beginning, you will have to decide it is one or the other, we have completely and entirely framed a full case, and this particular juror agrees with our framework. And then the next one, just for the sake of variety, this was a breach of contract case over a real estate deal. And so while some people in a medical malpractice case might draw the picture of a contract, in a breach of contract case, they actually drew a picture full of words and phrases that characterize the evidence. Money, 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 and lawyers getting paid. A contractor who says, I'm going to Farmville, USA, and I'll build you. But the contract is full of vague terms. And the landowner says, no, you won't. This depicts the entire story on a single page, but it also starts to talk about what the motives of the parties were, which is an essential ingredient that a lot of people would be surprised could actually be contained in a picture. And then the last and final one is from a case that Suann and I worked together on in New York. It was an employment case, and what you see on the left-hand side, I can tell you from the beginning, everyone on the trial team believed that gender would play a key role in how jurors characterize the case. And what you see are two women catfighting on one side and a bunch of men in suits holding money bags, laughing at the women catfighting on the left-hand side. That was the epitome of the evidence in the case. This told us they really understood what both sides were saying about this case. And I've shared all of these with you because when I'm about to tell you how I know Suann and how we've worked together, you can see that we've got this sort of perfect marriage between trial consultant with research background, trial consultant with graphic design background, and the litigating attorney can work together to create powerful show and tell for trial. So let me tell you about Suann for a second. When I first met her, the first thing I learned about her is that at a very young age, she'd been a hotshot graphic designer for Coca-Cola, which I just thought was too cool because that meant she was working for one of the biggest companies in the world, creating ads that had obviously been very powerful for me as a consumer who doesn't love the polar bears, right? So I don't know if that was Suann's design or anything like that, but I knew that that's what she did. It took me years to realize that Suann since then has worked for almost every trial consulting firm that has ever been incorporated in the United States of America. She's on her own now. What I love about her the most is she's an eternal optimist. You're going to hear Suann tell you that there is more than one solution to every problem, and it could be either her bumper sticker or an actual life motto for Suann. Every time I think we're about to run out of ideas, Suann makes more. And some people would accuse her of being ADHD for doing that, but I see her entirely as sunshine and optimism, and she brings that spirit and that willingness to solve the problem as many ways as it can be solved to every case and every situation that we've ever worked on together. So I'm going to turn it over to Suann. I got a sudden case of laryngitis on Monday, which is why I sound like a barking seal. And I'm going to take a rest and come back later when it's time to answer some questions because Suann and Bob have some great examples of the work they've done together to share with you.
Thank you so much, Charli. That was very kind. I will start right with knowing you. Charli and I met in the American Society of Trial Consultants at least 25 years ago. And the thing that stands out for me with Charli is she's constantly doing the levels of why. Why? Why is that? Why is that? And doing things about the answers. I was very impressed from the start. She graduated from the University of Kansas in the first trial consulting program that I think, Charli, does that still exist? I think it still does.
It does still exist. You can do it at the master's level or the PhD.
Yeah, and that has always been a very good thing for me as somebody who's been to trial with the technology early on to A, use a different color besides Coca-Cola red, and B, to learn from the input that Charli's brain brings because she's able to think freely about what attorneys don't know they don't know. I think that has been very key and has really improved my work. Also, around 25 years ago, I met Bob Weigel, and I feel so lucky that I've been involved in some of his biggest cases. And I remember hearing the B word, the $1 billion cases, before anybody was talking about $1 billion. And one of those cases just resulted in so many examples we're looking forward to sharing with you today, because everything we just introduced to you, the whole idea of handwriting and thinking about ideas with a blank legal pad, I was able to be a witness to see Bob bring them together for his teams. He's usually surrounded by really bright attorneys and Fortune 100 companies that hire him. I've seen him make his clients in very demanding cases happy when happy wasn't even a goal. You're able to make them happy. And I feel really great that I was able to bring the three of us together.
Well, I will just say that, I consider it one of the great good fortunes of my career that I ran into Suann Ingle sometime around 2000, I think. Mm-hmm. And I can't tell you how many times in my practice I've explained to associates and others that chart really doesn't work. And you obviously have not spent enough time with Suann Ingle because there are footnotes on it and there are way too much information and nobody can read it. And we'll try and show you in, I guess, the remainder of an hour or so, what Suann has taken 20 years to try and teach me, but hopefully we'll be able to convey some of that.
Be great. I think this is a funny thing to start off with, but this is a situation, and I wanted to make sure we mentioned it, where hundreds of graphics have been generated. And the answer in this case was to go back. Both sides had exchanged graphics right before trial. The solution was going to be who drew the red line better, the person who curved it or the side that made it sharp. And so we came up with this idea that at the very last minute to just show it. Why don't we just show the devices at issue and let the jury decide? If our expert really convinces them that these shapes were curved, we win. If they think they were sharp, we lose. And that's exactly what we did. And because, as Charli said, I'm the eternal optimist, I volunteered to be the person in court putting the tweezers on the LED units and placing them in underneath that microscope you see and taking a picture. And that became the evidence. So I just want you to know, as you listen to us, that we're not saying every single thing needs to have a graphic. We're saying, we're really thinking that it'll help you to understand, if you think about your visual strategy, weaving into your argument or your main themes, that's the way we think will give you the best chances. And that's evidence from that trial. One of the ways we do that is pen to paper. This is the theme of the day, pen to paper. We cast a wide net, and we often have attorneys say yes or no. Yep, no, no. And if they say yes, it's an iterative process. The old days are getting older, but this was the way we taught people to think visually, to analyze, visualize, design, and produce in that order. And very often it would take reading the main themes of a jury report. It might take reading the draft openings. And the only thing that's changed, these things still are required, is that this happens throughout preparation. So let's say you have 100 days before your mock trial or 100 days before your trial. These things can happen constantly, and technology is allowing for it because everyone's waking up and looking at their phones. So when you look at your phone, you're bombarded with images. How do you cut through that is part of the reason we have to think clearly about these case challenges.
It definitely is the case that well, you've got it up here now, the next one. When I started the first trials I did, you would have to plan ahead. Some graphic designer would put letters on a board, and that board would be it.
And
I mean,
film it and
you really
cover
could,
it, yeah.
you really couldn't, do too much on the fly. And we operated with overhead projectors and
That's right.
the sort of things that I used in elementary school.
Remember closing with Anthony calling in the changes that you were going to show for BBL's closing? We had to call them in. They had to be worked on overnight.
Right. And that just completely changed. But Suann, I interrupted. Go ahead.
Well, no, this is perfect. When do you think, we don't want the audience to think, oh, well, there's a perfect picture. We just have to create them in this linear fashion. At any point in your case, like when you're doing a mock trial with Charli or witness prep with Charli, you've got people drawing and thinking. And the Markman and claim construction hearings are pretty obvious, but pre-trial motions, I think it's interesting. I'm starting to get and see more and more people saying, I think if we could summarize this in a visual, that might be a good way if the judge does allow us a few minutes of an oral argument. And that's not always a given.
Suann, I wanted to call you this weekend when I was on a plane and I was reading a copy of a complaint. The first thing filed had a single photograph in color of a catastrophic wreck in the body of the text of a complaint. And I said, that's my kind of show and tell. And I'm not saying I worked for the plaintiff or the defense in that. I'm not going to tell you. I'm going to tell you that when I came across the plaintiff's complaint that had dropped a single high resolution color photo of a catastrophic wreck into the body of the text of the allegations, that's a lawyer who's thinking about how to show while he or she tells. A single photograph just to capture the judge's imagination. And I'm going to add one more thing before I go back off, Suann. I was at my grad program at the University of Kansas, and my mentor was Dr. Pete Rowland. And at the time that I met him, he was deeply invested in research about whether judges really judge differently than jurors do. And his conclusion from his research is judges are humans too. And so while there are lots of requirements about exactly how many pages you can submit and how you need a footnote and what the word limits are on any particular pleading, there is a time and a place where you are willing to give up a couple hundred words to make space for the perfect picture. And the more we do this, the more we also have a chance to influence all the decision makers along the way. If 99% of civil cases are settling short of trial, then we aren't thinking about visuals along the way, then we are missing an opportunity to convince our own clients of something that they need to be convinced of, to convince opposing counsel of something that they need to be convinced of, mediators, arbitrators, and even witnesses themselves. If we start to think about how we can incorporate the visual elements of our case, even in the depositions that we take, we are developing the show and tell of our case. So this to me feels like a really important place to say it can and should happen early and often.
And it's not, this list isn't even exhaustive. I mean, there are other places.
Absolutely. And some judges are more receptive to, having graphics and the like in a pre-trial setting, and some are not. But it can be very effective. And it's also very effective to get your case down to the 4 or 5 points that are really important. I think Suann's going to show us some examples of lawyers trying to do graphics by themselves. And, we're just not good at it. We want to cover every possible contingency. We want to footnote it.
They want their brief in color.
Yeah, basically. And so it's important to start this early in the process when you sort of figure out what your themes are. What are you going to be telling the jury? I mean, I primarily deal with sort of big financial matters. Oftentimes that's outside the realm of anything the jurors deal with. And the idea is, how am I going to make this simple and straightforward and put it in terms that the jurors understand without in any way sounding condescending, and make it explainable? And Suann is just masterful at that.
Thank you. What I thought.
Hey, Suann, can I interrupt just for 1 second and do our first attendance poll? All right, here it comes. The question is, which of the following free upcoming Academy webinars are you most excited to invite your friends to attend? Your options are: don't be fooled by 50A and 50B, crack the code on case costs and settlements coming up on April Fool's Day. Get it? Don't be fooled. Federal Court Confidence, successfully litigating personal injury cases, part 1, overview of the federal court process on April 3rd. We've got Under Oath, Above Board, Mastering Deposition Ethics on April 9th, or The Price is Right, Calculating Costs in Construction Accident Cases on April 10th. Choose any one of those. That's how we'll know you're here paying attention and therefore worthy of CLE credit. All right, Suann, back to you.
Thank you. It's interesting because as many choices as we have for media, or as many personalities there are, equals how many opportunities you have to do it well, and then also not be afraid to be in a position where you have to practice or in front of a group. Don't let the first time you use an idea be in front of a jury or a judge. So choose the tools that are appropriate. Test. I often say if the stakes are high enough and we think our ideas are great, test them. Test the presentation, test the way you're presenting the information. Go to the courtroom. Does the courtroom have a plug? Often they do, but do they even have Wi-Fi? And I used to think Wi-Fi was just a hindrance because we're constantly interrupted, but now it's a prerequisite. You need good Wi-Fi. So just the art of war tactics of getting to the battlefield. Check out where you're going to be, and don't let the first time you do it be in front of a jury. And backup plans, oh my goodness, backup plans. I am all about backup plans. I think it's my days as a Girl Scout. And if you want, here's a reason, for instance, we always have a backup print. And the reason for that is technology goes down and it doesn't stop the proceeding sometimes. So I've been in situations where the attorney will then just hold up the print. Or there was a situation where we rehearsed this long, complicated story over and over and over. And during the mock trial, the projector went down. And there's always this idea that you could have a backup projector, but no one really thinks about the idea that it would double the cost, or that it's not always practical to have another projector sitting there running. So there's always going to be a little bit of a disruption. But this attorney had practiced so much, and Bob is one of my favorite proponents of rehearsal, that he was able to talk about the visuals, and so they had a value even though people couldn't see them. So if you could see the board composition, it was made up of this. And I really think that was because he had rehearsed and understood the technology.
My favorite trial story was Suann. One of them was that this was the trial we're going to talk about in a little bit. We were having a good day. We had beaten up their witness, and they had one deposition clip that they wanted to play on a Friday afternoon, and they figured they were going to close out the weekend with this dynamic deposition clip of our client's very good friend and board member who looked like a gangster in a Jimmy Cagney movie. And they started to play it, and they got about 30 seconds in, and then it crashed. And then they tried it again, and it went for a minute and a half, and then it crashed. And the jury is getting frustrated because it's Friday afternoon, and its steam is coming out of the judge's ears. And finally, after about 20 minutes of this, an old timer grabbed the deposition transcript and said, "Okay, I'll read it."
And that, yeah, that
and
really.
It completely lost all its force, and I never understood where Suann got that big magnet that she walked by the guy's computer. But
he leaned over to me and he said, after we ended the session, find out what happened so it doesn't happen to us. And that was so true. I mean, it's user error. It's also sleepless nights. There's so many reasons that could happen. But that brings up a great point, because the reading, when you read something, you have a little bit more control. So there should be deliberate decisions even about that. I bring these two samples here in so that people see, when you're doing your own graphics, we often see this in court, the bad document, right? Everybody has bad documents. And then you want to highlight a line, and people will they don't know how to do it in PowerPoint. So they'll put a little yellow line. The lower one in this example is a semi-transparent yellow box trying to highlight that does the exact opposite. So it makes shall not include reimbursements for any parts harder to read than it does making it better. The one on top I tried by just knowing that you have layers of information, and the yellow box is laying behind a quote transparent box, but even the transparent box has issues because the documents are so old and spotty. But this is something that I often see attorneys try. And I do think it's helpful for the team to understand the documents, to understand what is important, and also to figure out if you're going to show it. How are you going to do it?
And before you leave this, Suann, let me just also say a couple more things, because this is the most common way that my clients are at the last minute preparing for the mock trial. And so they get all the credit in the world from me for being willing to run the research before trial. That's a big deal. But then at the last minute, they're thinking about how important this document is and how important the keywords are. And this is what they show. I was just at a mock trial in upstate New York about a month and a half ago, and they had done this with every one of a lot of key documents. But they had been sitting in a small attorney's conference room that contained a giant wall mounted screen. So their perception of how readable it is was completely distorted when we got into a large room, like a courtroom space, and had still large monitors, but then rows and rows of people had to be able to see what was on the screen. And so we understand and recognize that for many years, if not decades, this has kind of been the go-to way for lawyers to DIY their way to presentation skills, when in fact, if you don't get out of your own small conference room, or you don't test it out even with people in your own office, you'll sometimes miss something as simple as, I'm still straining to read that document. And so if people on your jury are leaning into their monitors like this, even with the individual monitors they have in a jury box sometimes, you know that this thing you did to make the document readable is not actually working. And if you can do that in a focus group or mock trial, and you're paying attention to the show and tell process itself, you will pick up even on the nonverbal cues of everyone doing this to read your document.
It happens
Thanks
so
for
much.
letting me interrupt.
This is I want to get through these, but this is an example of how you might do it better. It's very simple. It's not a do-it-yourself from an attorney's standpoint. And if it is, call me. I can offer you a job. So we dim the background a little bit once the call out comes up, and then the yellow is this is a good example because the handwriting, there's no way people could understand the handwriting anyway. So this is a handwriting font. Here's an example quickly of a contract come to life. This is the timeline of the relationship. This is what MRS was going to give, and USFR was going to give this. And of course, it went wrong, and you're going to hear all the details. There's a lot of literature. We're going to put these in the handouts when we finalize our packet with Michelle. There's a lot of literature about what happens in the brain when people are handwriting more than it does when they're typing. In fact, I just read a recent Norwegian study and was surprised that even the handwritten stylus, I thought it was always pen to paper, but it's a stylus was had better resulting neurons firing in people's brains as they were integrating the information. And this is what I saw Bob do that we're going to show you. I saw this happen because it's got better imprint when you're writing it yourself. Either your brain can keep up with it better, or you just have a better grasp of it because you've authored it. But it's really something that I assure you these attorneys would that you as attorneys would benefit from. And here again, we'll put this in the bibliography, but these are texts that all say the same sort of thing. So what we've done here is recreated the sketch that we keep talking about that Bob and I were working together on, but this is his work.
Well, Suann asked me to come in and talk about these things, which this trial was quite a while ago, and it's tacked my brain. But when someone has worked through the night as many nights as Suann is for me and asks you to do a favor, I'm happy to come and do it. What we're trying to show here, this case involved the failure of Executive Life, which was at the time the largest insurance failure in the United States. And Executive Life had owned $6 billion of junk bonds. The junk bond market had cratered, and that brought Executive Life down. My client was not involved in the restructuring of the company, but we bought $2 billion worth of junk bonds from Credit Lyonnais, or Altus, who had bought the junk bonds from the insurance commissioner as part of the restructuring. And the insurance commissioner was basically asking for a do-over because the junk bonds did very well, and Credit Lyonnais made a lot of money, and my client made a lot of money on this restructuring. And even though the restructuring went perfectly and all the policyholders got 100% of what they were entitled to, or 90% of them did, insurance commissioner was contending that he would have never sold the junk bonds if he'd only found out that Credit Lyonnais had concealed its connections with the companies that bought the insurance company. So one of the things we were trying to do was figure out how could we explain to the jurors that we bought $2 billion worth of junk bonds from Credit Lyonnais, but they weren't the same junk bonds that the commissioner had sold to them, because Credit Lyonnais had been trading these bonds for 10 months. So I sat down with Suann and I just started to draw, and this is why, of course, I hired Suann, but this is not my drawing. This is somebody.
Well, this is, let's go back to yours. So this was you, and if you and I had not been together, I never would have been able to describe that to somebody who was going to actually produce this.
So the idea was that in March, Credit Lyonnais spent $3 billion to buy these junk bonds, and in December, my client bought $2 billion worth of the bonds, but we didn't buy the same bonds. And so Suann is trying to pull this together.
And this represents what you.
All right, so this is how it ultimately ended up going to the jury. So that's John Garamendi, the insurance commissioner. It was important to show that Credit Lyonnais actually spent $3 billion, which is what made the whole insurance company rehabilitation work. But there was a lot of time passed, and Credit Lyonnais had sold a bunch of the junk bonds to other people. And then when we came along in December and bought these bonds, we were only buying 21% of what the commissioner had sold, even though in face amount it was 2/3. And this was important because the commissioner was trying to claw back the profits that were made on the junk bonds that he sold. This was, as I said before, there was an insurance company that was created out of the $3 billion that Credit Lyonnais had paid, and it turned out to be a great success. But the insurance commissioner was trying to argue that Credit Lyonnais, in fact, backstopped these 4 companies and agreed to buy back the shares if there were any problems. That we were trying to show that that was something that that was actually desirable to the insurance commissioner. And they were trying to argue that the identity of those 4 companies was important, and those 4 companies had to own it. And we showed that, 2 of the 4 had less than $50,000 in assets, and Credit Lyonnais had $305 billion of assets. So we spent a lot of time trying to figure out how thick that line could be at the bottom, because you really couldn't make it accurately small enough. But the whole point of this slide was to say Credit Lyonnais was the reason they did this deal, and Credit Lyonnais was the backstop behind the whole deal. So we use the word backstop, and Suann, of course, came up with this.
Well, and this is also, if you remember, Bob, there was a lot of sketching and ripping up pages and trying to figure out how are we going to do this. And this was the result of the team. You had a really good team. We sat in a room for a couple of days, probably trying to figure out how do we make this work. And this was the resulting thing you closed with, I think, right?
The idea was not that we cared what these companies were, but the point was that they kept changing, and that nobody really knew anything about these companies, and they weren't really important to the deal. It was all that Credit Lyonnais was there. And
right.
So this just shows the companies that were, kept changing, and nobody cared. The deal kept moving forward. And then we ended up.
As someone who did not work on this case with Suann and Bob, and someone who's seen a lot of graphics, I just want to highlight something that goes back to our very first slides. It took thousands of words between Suann and Bob and his team to figure out what the image should be. And then once you've done that, what I love about the animation of that last series that you showed, Suann, is that it's a lot of information that's coming and going, but nobody is required to read every word on that screen. Nobody needs to have every word on that screen read to them. We don't just stand next to a PowerPoint and read every word in every graphic. We use the animation, or a skilled graphic designer uses the animation to sort of throw things away appropriately into a wastebasket, to label the backstop. mean, the idea that Bob probably had said 1,000 times, credit Lyonnais was the backstop, like they were holding the whole thing up, is what conjures up the image and then gives a good graphic designer an idea about how to make all the information move. No one in a million years will ever be able to repeat the words that Bob said about junk bonds and insurance commissioners. And no offense to any of the jurors in any case, because they're not stupid. After 30 years, I think jurors are doing the best job that they can in every case that I work on. But the point is, they don't need to have your language. They need to have the concept that the bedrock in this case was credit Lyonnais. It was the biggest and it was the backstop. And so we get hung up sometimes on what needs to go in the picture. And if you can drop back and see it with new eyes as I'm seeing it, as the consultant who didn't work on the case, what I'm taking away from it is it's the motion that you gave to those images. It's the size and scale that you considered in those images, but it is not all of the words. And those words in movement and in graphic form are more powerful than expecting me to understand even the argument itself.
Yeah. Yeah. And to keep pen to paper. I mean, here's another example of Bob trying to get the team to understand we've got to show how nonsensical the demand is. And look at this comparison to any of the other fines in similar situations. And this is what we came up with, all based on a sketch that came up during a brainstorm.
Yes, exactly. And this case was unique in the sense that as we went to trial and we're picking the jury, my client was the third defendant. Credit Lyonnais was ahead of us. This company Moff was ahead of us. And our defense was largely going to be asking the witnesses confirming that they never spoke to my client, they never knew my client, they never had anything to do with my client had nothing to do with the rehabilitation or what Credit Lyonnais did or did not disclose to the insurance commissioner. Literally, as we're picking a jury, Credit Lyonnais settles, and Moff, for whatever reason, decided that they were better off under French law by defaulting. And so they left, and suddenly we're the number one, we're the one and only defendant.
We had never prepared to be number one.
But one good fact that came out of that is that Credit Lyonnais paid hundreds of millions of dollars. So if we had lost this case for $8 million, we were going to open up a case of champagne. So we had a lot of room to play with. And then the point was simply, these are the kind of fines that the insurance commissioner gets for the kind of violation that they were accusing Credit Lyonnais of engaging in. And yet they were claiming $4.3 billion from my client. And, you know, we'll see later on, ultimately, we did goose egg them here.
Yeah. What I think is important, Bob, for the group today is to know that we did these many years ago and you were able to remember. You said to me, what about the junk bond, the quotes that the commissioner actually used in referring to these bonds? And we came right up with it because we had created this. And so I think that in itself proved the value of the visual.
Sure. I mean, we could have read in, and we did in his cross-examination, you know, all these, he was a politician. He wanted to tout what a great job he had done on this rehabilitation of the insurance commission company. And it was a great job. Everybody got paid. It turned which was really what was a sinkhole turned into a great success. And Garamendi was criticized at the time for selling the junk bonds. And so he was constantly denigrating them and talking about them as toxic waste, trash, the worst of the worst. Now he was suddenly telling this jury, well, I would have held on to them. Yeah. It was important for me to hold on to them, and I would have made billions of dollars. So this was just a very neat way of condensing and showing the jury, reminding them what they'd heard of before, how much this guy had really just criticized these and how he, as a politician, could possibly have done a 180 and suddenly said, yeah, it's great, we're going to hold on to them. And we ultimately convinced them that he wouldn't have done that.
we were so lucky in this whole series of events in this one case, because 7 years passed between the visuals we've already shown you and this representation. And I think it says a lot, and a number of mock exercises in between, right? I mean, we tested every chance we got. And this was the way we ended up teaching it.
Well, we tried this case twice. Once we won one on most of the counts. The jury did find that my client had entered into a conspiracy with Credit Lyonnais, but then hung on the damage theory. We then tried a brand new damage theory and goose-egged them on that. And then the Ninth Circuit, in their wisdom, said that they should go back and be able to try yet another damage theory. And this is from the 2012 trial.
And I think it really brings it all together in a way that it's difficult to convey everything right now, but unless you sat through those total of 3 months of evidence, right? But that is what you ended up with, the best capitalized, safest insurance company in America. And he said it.
Right. And so our argument was he wasn't going to give up this in the hopes of a lottery ticket to continue to own the junk bonds, which he had criticized so soundly.
Yeah.
And Suann is right. I mean, it's amazing. It was quite a while that we did this trial, and yet these slides stay with you, and that's the point of them.
And speaking of that, we were going to close with this, Bob, because I was in court with you, and I think on your way to the podium, you said,
"Oh, we had a second judge, a new judge for the retrial, and in the middle of the trial, he all of a sudden decides that he's going to exclude most of what our expert was going to testify about, namely what Garamendi should have done in that situation, and instead would only allow our witness to testify about what a reasonable insurance commissioner could have done." And this was incredibly annoying because we were in the middle of the case, and it had all been resolved by the prior judge as to what could come in and what couldn't come in, and this guy just had a different view on it. And I am going up to the podium, and there had been a voting trust that had been put in place between the foreign companies that own the insurance company and the new California insurance company, which satisfied the California regulatory requirements. But we weren't allowed to use that slide because the judge excluded it. So I said to Suann, "Can you just make me a generic slide with American Voting Trust?" And literally, I've got my notebook. I'm up at this podium, and she says, "I've got it." I said, "Great." I hadn't seen it. I don't think I saw it before we showed it to the jury. But at that point in time, Suann and I trust her completely.
Well, and that brings up a good point about the graphics, because during this 7 years, a lot happens with technology and design trends. I mean, you'll hear a lot of people who do visuals for trial have a right and a wrong way. And I just don't subscribe to that, because what's right for you might be wrong for that person, on and on and on. I mean, the variety is undeniable. So I remember during the second trial, one of your team was like, "Suann, these are ugly." And there were parts of that criticism that were true, but I really felt that especially since I had been in the first trial as well, that we just had to stick with what worked well for us. And I didn't think change for the sake of change, or design fads and popularity, I just didn't think that was a reason enough to change a whole series of visuals that this team, a very sizable team and client, were used to and that had worked. People don't think really about that whole aesthetic, but there are decisions to be made at every point.
Well, and I do think, Suann, that a lot of the conversations that I'm in on trial teams who are pre-testing, thinking about drawing, hand sketching, I'm a big fan of lawyers asking witnesses to draw pictures in case that might be fruitful. I think in your work with experts, it's really important to either you can furnish them with photos, obviously, of an accident scene, or you can furnish them with, the actual product that you're asking them to opine about, but asking and engaging your experts in sketching for you is really powerful. And then ultimately what it looks like, I think you're right, that idea that we all have some kind of personal taste about aesthetics. I can be really picky about color. Like I can be really picky and critical about color, but it doesn't matter as much what a consultant or a lawyer thinks is the best thing to do. It is always best to test those things in your focus groups and your mock juries and see what they like. Because they might
Yeah.
like something that you think is ugly. And you're going to do what works best, even if you
Right.
think it's ugly.
Yeah, I mean, ugly is in the eye of the beholder. So
Right.
Well, one of the things about this slide, and this is again one of the reasons why you want to do this, is our expert was testifying. You could have put a voting trust in and so forth. $4 billion trial. We put it in, I guess, in 2 weeks, maybe.
yeah,
The jury asked for one exhibit, and they asked for this one.
isn't that great? It's so funny. I forgot about that.
And they asked for it on Friday afternoon. We were convinced we were going to get a verdict, and we didn't get it. They came back Monday, and they hung, and we gave them an Allen charge. And then finally, at like 3 o'clock, they came in our favor, and we won. But I'm convinced that that gave them the opportunity, because they had this, and we managed to get it into evidence, that they could call for it, and they could look at it, and they could see it, and they could discuss it, and they could say, yes, he said this is the way they could have solved that problem. They didn't have to throw out the whole deal.
Yeah.
And because we had it in a simple graphic, they were able to use it to convince whoever the holdout was that that we were right.
It's a good feeling.
I don't know if you want to.
Should I
yeah.
jump into our second attendance verification?
Oh, after this, Michelle, how about this?
Okay. Okay. Go.
It's the last slide. I had to put it in because they had such a good coverage after this very long road to winning. But I've always appreciated this press.
And I was much younger and my hair was not gray.
So congrats on that. That was a good road to victory. A long road. Okay, Michelle, sorry.
No worries at all. I love it. Okay, so here is, I'm going to launch our second attendance poll question, but don't go anywhere, everybody. Here it comes. This poll is brought to you by our newest sponsor at Vanquish. Which of the following best describes your current disability insurance situation? Your options are: lost my previous coverage. I had coverage through a former employer, but I lost it when I left. Never had coverage. I couldn't justify the cost previously, or I didn't feel the need until now. Current coverage is insufficient. My coverage has not kept pace with my current income growth or needs. Uncertain about the options. I find insurance products or pricing confusing and expensive. Or your last option here, I have workplace benefits only. I have group benefits through work, but I'm unsure if they provide adequate coverage for my needs. Lots of options there. Hopefully something you all fall into one category or another. And that is how we will know you are here and therefore worthy of a CLE credit. So there's only a couple questions in the Q&A, but we'll see. You never know. People might start the flow of questions and then it keeps going. If we go all the way till 2:30, we'll get to a bonus credit and I'll do an additional poll question then. For now, I'm going to leave this attendance poll question up for a minute or two, and then I'll put up our evaluation form and you guys can wrap up. Sound good?
Yeah.
It's perfect,
All
right?
Back over to you guys.
So Suann, while they are finishing the second poll, I'll tell you there are a couple of really thoughtful comments that I've responded to in writing. People highly interested in the topic and really grateful for all of the examples that we shared. And a few questions that I said we'd like to answer live. And so I'm going to toss one of the first ones to you, unless you have more slides to go. I can't, from memory, I can't remember.
That was a good, that was a good
so this toss, I think, takes us into more discussion that we can all weigh in on, but I'll start with you, Suann, because I think it's designed for you. Can you discuss the price structure for consulting on case graphic ideas and for implementation. And so we need to talk about all of that because it does feel like the most obvious question that someone would ask if they think we're on the right track about suggesting graphics at all.
Right. I like to tell people the work is free. We only charge for iterations.
And by iterations, you mean changes and
Revisions.
versions and revisions. That's right. Well, and let me also change the question a bit because the question contains the phrase case graphic ideas. And the reality is that I don't do graphics, but I sketch a lot of ideas. And I use my words to describe what I would like a picture or a live demonstration or a photo to be when I make a recommendation about what's the key pieces of evidence or what's the strongest argument that we can make. So let's make sure, even though we showed them a lot of examples of graphics, that when we say visual presentation and show and tell, it runs the entire gamut of what you can show and tell about. And so to answer a question on price is hard to do because the best idea for your case might be a single photo. The best example in another type of case might be a very interactive electronic timeline that is also supported with a series of exhibits that will also stand alone and needs a really integrated, seamless, hot seat sitter kind of presentation. So how would you start to tackle price and implementation, knowing that we're talking about a whole body of possibilities, not just graphic design shown on a PowerPoint?
Right. Well, especially when you're talking about court and hearings, because there are so many start and stops and interruptions and objections that get ruled on and you have to adjust. It takes very little graphic design sense and a whole lot of experience and service sense. So are you thinking, not you, Charlie, but when you're asking about price, that the best answer to that is it depends. But the more clear answer to that is tell me what you think you want. And you have relationships with people who have these skills, and I'll tell you what it should cost. And at every step of the way, tell you why it's changing. I just last week had a case like this where we had it all down. The quote was tight, and we ended up in an in-person meeting that resulted in better deliverable. And that deliverable cost a little bit more money. And the case settled, so they didn't really know until they got the bill, which was only days after that. But that kind of thing happens all the time. And so I can't stress enough the value of the relationship that you have with the person who's going to do what they do. And it happens in experts. I think with experts all the time. The expert says, okay, this is the scope you're asking me for. And they sit in these meetings. And I love being able to say to attorneys, well, you charge a lot of money, right? Your rate is pretty high, right? Well, I'm only a fraction of your rate.
I will say that, I mean, look, when you have a $4 billion trial where you've actually got a client willing to let a jury come in and tell you whether or not you won $4 billion or lost $4 billion, you certainly have a lot more leeway in terms of what you can do in terms of graphics and the like. But I have found working with Suann that, the important thing is I call her up and talk to her. I said, this is a much smaller hearing. It's this. I need 3 or 4 graphics. This is kind of what I want to look. And you have to be practical about what you can do on a smaller case. But I've always found Suann to be very reasonable about these things. And I think if you have a case, the important thing is call up and talk, whether it's Suann or I suppose there are other people out there. I don't work with them.
I don't
But
know.
try and explain to them what you need and what your restrictions are. And Suann, at least in my experience, has always been willing to work with me to try and make something that your client can live with, and that will make your presentation better.
It is a very
And
specific.
Suann might be the one who doesn't design 15 graphics. Suann might be the one that says, take a picture of those processors and show it to the jury.
Yeah.
Because the decision is curved or shaped, right?
Right.
So I think when you find reputable providers, they are always willing to only sell you what they think is the highest and best use of show and tell. I can also tell you this, and I don't have, I mean, I have favorites for sure. Suann's a favorite. But there are lots of trial consultants like me in the world. There are lots of graphic design trial consultants with Suann's background in the world. There's kind of no barrier to entry in our field, so it's a little bit of a weird space. That relationship piece that Bob is talking about is really important. Get somebody on the phone. I've never charged anybody for 30 minutes of conversation. It just doesn't happen. I want to help steer you in the right direction. The greatest thing that could come out of attending the CLE is that one day in the future, you'll send me an email, or you'll send Bob and Suann an email, and you'll say, you really got me interested in thinking about what the best show would be. And I did this, and here's what I got. 2 more questions that are still pending that I want to move us to. The second question that we had on tap was whether the demonstrations, like the ones that you're talking about, are used in motions hearings. And I say yes, yes, yes. And this is back to my mentor who said, judges are people too. They're just as bored with 20-page pleadings and people droning on and on without having a picture to tell or a demo to do.
Yeah.
They have the same predilection we all now have for lagging in attention. One of the great articles that I ran across that sparked this conversation for Suann in the first place was an article, I think, that came out in the Atlantic. And there was an expert in that article who was quoted as saying, we don't really think that people have lost their ability to pay attention for a long period of time. They still go to 2-hour movies. They still sit through plays, but there's showing and there's telling. And the bottom line in that article that I thought was so clever was, above all, don't be boring, right? So just don't be boring. And it doesn't mean that it's a particular type of graphic or it's a particular graphic artist you have to hire to not be boring, but don't be boring with judges either. And don't be boring with mediators. And don't even be boring with opposing counsel, because in the mediations, you start to move the needle on the value of your case, knowing that most cases aren't going to trial.
Well, I mean, I'm sure you're right. I mean, these days we all get all of our information from screens. I mean, just try and buy a New York Times on the way to the subway now. There's all the newsstands
on the weekends.
All the newsstands are closed.
Right.
But so I think that makes the graphics more important because everybody's used to looking at a screen. They hear the witness. They hear the witness talking. And I think somebody was asking there whether the graphics are really evidence. I mean, sometimes you can get it in depending on what it is and so forth, but most of the time it'll be in as a demonstrative, as a chalk or something. Yeah. But the jury will be allowed to go back to it.
And they'll remember it.
Yeah. And I think that's crucial, but
evidence is in the eye of the beholder. And so that question of whether it's evidence or not matters not to a jury. And if that's the ultimate decision maker, great. If it doesn't matter to a mediator, if it doesn't matter to the judge in a hearing, if it's persuasive communication, it's persuasive communication. It's not a more or less, greater than or less than, or even a measurable weight. It's really measured by the impact it has on the ultimate decision maker. But there are lots of decision makers over the lifespan of litigation. And that's the place where I'd say, when I've seen summary judgment briefs that incorporate a photo, a graphic, or something else that is visual, they're willing to cough up space on a page. They're willing to let go of a couple hundred words because there's something visual that matters. Suann, I'm not sure, I know we've talked about it each time we prepared for this today, but I'm not even sure that you quoted the judge who ultimately decided which graphic was going to be given to a jury. And remind us all of what that quote by that judge was.
The wanton, this
yes.
is Judge Motz. This is the same case. He said,
yeah, I think I didn't hear you say it today.
I'm going to be wanton and arbitrary in my, I have hundreds of graphics here, so I'm going to rule that some can be used and some can't.
I mean, even the judge was saying, like, I don't need hundreds, right? Like, I'm just going to make a decision about which one of these. And I think it forced you guys to go back and say, well, if we're not going to get all of the graphics that we want, we better get the one shot at visual communication that we need to take. There's another question here about whether We have incorporated AI technology in our work, and I think that's a great question for you, Suann, because it's a very nuanced answer for
Yeah,
me, for
and
sure.
the American Society of Trial Consultants just recently did an AI webinar last week. We're not using it to, we can't, AI is just still full of artifacts and junk. It's still the junk of the junk. And so we're not using it to create, at least in my shop, create demonstratives, or because they have to be based on fact. So we're having some issues there. The animations that can happen are almost too real. I saw recently that a judge was wearing a virtual reality headset to watch an accident recreation. I don't know. I'm not there yet. But I want to mention one thing about something you brought up, Charlie. The judge in a hearing, he gave our client half an hour, and when we showed up because we wanted to show something a little bit more advanced, it needed some technology, and I don't do anything if I can't test it. We were in there to test it, and his clerk came out and saw what we were doing and said, "Oh, you're going to need this for the hearing?" Yes. Well, he gave us 2 hours for the hearing. So technology can have great serendipitous effects, right? So during the hearing, we had animated what we thought would happen in this. It was a case where the bottom layer of the payers were never going to get to their layer. And so we had animated it. So when the judge looked over at a moment during this hearing, oh, you could see the light go off. He understood it because the visual created the whole argument. It was really interesting to be able to see that. And we never would have seen it if we weren't in there testing the equipment, asking for the time to set up, on and on and on. I mean, there's great little serendipitous benefits. There's also a question about the chalks, like handwriting. I think it was I saw a question. Somebody said they like to get up and draw themselves on a. I have been in a situation where I've helped, who just lightly outlined. For instance, they wanted to show a timeline, but they wanted to hand draw it. They didn't want to exchange it. They drew it themselves, but there was a little bit of a hint of where they should put the line.
Look, I marvel at people who have those skills. Personally, well, you saw my attempts. I realize that there's value in that, doing that if you can. I can't, and it's good to know your limitations. I would get a D in penmanship all the time, so I'm not about to like start drawing things.
But it works for you. It works.
It
Bob,
works if you can do it.
No, it works
Bob,
for you.
there's a question in our queue that I think is great for Bob. It says, are the graphics and other works produced subject to the rules of evidence under rules for experts, or a different rule, if any? And I would love to hear a legal answer to that, because I wouldn't have one.
Well, I think it depends on what you're talking about. I mean, a photograph of an accident scene or whatever will actually go in as evidence, right? I mean, that will be evidence like anything else. If you're illustrating your expert's testimony and putting something up, that is something that oftentimes they will mark as a demonstrative, and you'll be able to put it into evidence, at least as a demonstrative, and that the jury will be able to see it and call it back if they want. Stuff that's in your opening and your closing usually doesn't get in, obviously.
I remember showing the list of transactions in the BBL case a lot, and that was a demonstrative. The list of the $123 million.
Well, if it's truly just a summary of evidence,
right?
You can often get that in as a summary,
right? And so I thought the design of it was helpful.
Yeah.
I will also chime in to say that, let's say we've done a mock trial and we're 2 months out from trial, and we know absolutely that the linchpin of our case is a detailed timeline, right? And that's the one I described, where it probably needs to be on an old-fashioned, stand on an easel, physical board that can stand up and kind of be the anchor piece for our case. But within every entry on a timeline, there are details from there that are really just exhibits that go up on slides on a screen, because you're going to show them the details of a document, for example.
Or the paper.
All
Oh,
of these things are potentially interactive. One point I would make on that last question about admissibility and evidence, I often say we could create a basic timeline of what we expect evidence to be for a version of the opening statement. But by the time we get to closing, we will have a highly detailed, busy, full timeline full of all of the evidence that has come in, which doesn't require us to guess about which gets admitted and which doesn't. We can build as we go, and we can have a version of a timeline that's just so much more impactful by the time we get to closing. The problem is we can't wait until closing to show a timeline. If it's important and central to your case, it cannot wait. You have to find a way to make it usable in opening, which means you probably need to be able to articulate to the judge that this thing I want to show is what we expect the evidence will be. And that's why you're working with your collaboratively with witnesses, both experts and facts alike during the discovery process to say, if you need a picture, if you need something to illustrate what you would say about this, tell me what that might be. Because if that's the testimony I hope you're going to give in a trial, then that's the testimony I can refer to in an opening statement. The
Yeah.
evidence in this case will be XYZ, and you will see a graphic depiction of that that will help illustrate the testimony of the doctor who's going to give that testimony. And in that way, and I know all of this is easier in state court than it is federal cases, we've all done a lot of both. And so I don't want anyone to think that I'm giving you a definitive answer on what's going to be admissible in your next trial. But we do think it through that way, that if it's going to illustrate key testimony that we know will be evidence in the case, then it feels like fair game for opening. And we need to design something visual on that particular point because it's so critical that can meet the standard for being in the opening statement. And it might be something different, more detailed, and even more argumentative by the time that timeline is shown again in the closing argument.
Yeah, starting with the end in mind is really a key. It's a key to success that I've seen over and over and over. You just start with the end in mind. And if that's where you want to end up, you got to back up and start there. Charli, did you see any other questions that might?
Yeah, I'm kind of trying to filter these. I'm so appreciative that people have great questions for us because all of these are important. This one for Bob, have you objected to certain graphics and been able to keep them away from a jury? What grounds was the objection?
Ugly.
Now, ugly doesn't work, but misleading does. I mean, obviously the point is if the judge has excluded something and they put it up on a graphic, or they're saying something and it doesn't actually reflect what the witness said, those sorts of things you can object to. In theory, you can also object if it's inflammatory or too graphic. It's not really in the stuff I do, but if something is bloody or whatever, you might be able to keep it out on the grounds that it's.
I've seen those arguments about which color on the graphic is unfairly prejudicial to the other side. Like I've seen some of those arguments happen outside the presence of the jury where counsel has exchanged exhibits or the night before opening statement, they've shared what they want to both be able to show and tell. There's an interesting question here that's kind of long. I'm not going to read all of it, but it goes to this issue of, do I show my hand by asking for things to be included by way of motion in limine, or do I hold it in reserve and keep it for surprise? And most of the time I would say to you, if your case is really well developed, you do know what the other side is going to attempt to do, even if you don't know what their graphic will look like exactly. And if they're preparing for you, they're doing the same. I don't give a lot of weight to the big smoking gun aha surprise moment that happens inside of a trial. Like, I think better preparation, careful planning, show your hand if you have to, and trust that you know how to respond to what the argument will be, or you know how to respond even to a counteractive demonstrative that gets developed during trial to try to defeat what you did first. I mean, as long as everybody's engaged in the process, that's going to be more productive in front of the jury and the ultimate decision makers. So don't sweat it too hard about showing your hand on something, because it's very rare that I've seen a trial win with the big shebang surprise that occurs in the middle of the trial. What about you, Suann? You have a lot of courtroom experience
Well,
as well.
people love to take the other side's demonstrative. You know, there's usually an exchange that's electronic. They take the electronic thing, they print it out, and they put it on a document camera, and they cross off things they disagree with, and they end up with this really ugly crossed off demonstrative. I mean, almost any side could do, in any case, could do that to the other side because they disagree. I mean, there's always, and if they talk too much about the visual, it gives it too much credence. So it's an interesting test to see how much outrage you want to show about the other side's use of visuals. We didn't really have a lot.
No, I mean, I think most of the time that a judge will probably, because they don't want to get objections during an opening. So a lot of times the judges will insist that 24 hours before or something, you exchange what you're going to show in the opening. I'm sort of with you, Charlie. Once I figured out my themes, I've probably been banging them on everybody's head for a long time in the pretrial arguments and whatever. You know, you're trying, even if it's a jury trial, you're trying to educate the judge as to what you're going to do. Most of my good ideas are not, you know, once you have it, they're not really that, you know, they should be obvious, right? I mean, that if it's going to work in front of a jury, a good idea should be like, oh yeah, of course that's right.
Not dependent on surprise. It's really not, because it is usually a good idea. I got you.
Okay, I've got a couple more legal specific questions. I'm going to rattle these off, Bob, because I think you're the best person. Have judges requested your explanation of the methodology for graphics design in a trial? Do you understand that question, and has it ever happened to you?
Of the method, like how the graphic was made, is that what you think, Charlie, it means?
Maybe. Take your best shot at it, since we can't ask Peter directly.
I haven't had it happen to me. I mean, I have had judges say, what's the support for that? Where are you getting that from? And you should be able to say, you know, either so-and-so's testimony, this witness is going to testify about that, or here are the 3 documents that are supportive of that. You know, a lot of times before you're able to display something from the jury, the judge is going to, you know, have shown it to the other side.
Right.
You have any objection to him showing it?
It's kind of consistent with what we're saying. Like, a trial by ambush or a big bomb going off in the middle of the trial is unlikely. You're more likely to trip over the cord that cuts off the monitor than to land a big, fat, surprise, juicy punch in front of the jury. I think judges just sort of control the flow of information more than that. I have a different question that's related. Can speakers give some examples of overcoming evidence rule that the party proponent should have a role in preparing the evidence? That sounds like lawyer talk to me, and so I don't know how to answer that.
Well, they usually do. At least when I've worked with your teams, the party says at my direction, this was made.
Oh, and she followed up to say she's specifically referring to demonstrative evidence.
Right. So at their direction, we're creating this. I think that's the way we deal with that.
I'm, and maybe late in the program, I'm not quite understanding that. I mean, obviously you have to be able to explain to the judge where you got this and what it's demonstrative of. And if it is going as a demonstrative, you really have to have something. You have to be able to show that there's evidence in the record to support it. But I think if you can convince the judge that it's not confusing and it's not inaccurate, most of the time you get it in.
As a demonstrative aid.
As a demonstrative aid.
And it's become second nature. We're sourcing everything we put on these pretty charts.
Plus the other thing is, if it helps the judge understand,
yeah,
and he thinks it's valuable, he's gonna let it in.
That's right.
So it's, in some ways, it's just, it's a
I
quality
mean, the
thing.
judge in all of your motions practice and in your hearings, pretrial hearings, is kind of your ultimate last focus group test of whether this thing that you've developed is meaningful, persuasive, helpful, instructive, illustrative. I mean, if you're trying these things in your hearings and with your judges, you should. I think in one of the questions that I answered directly, somebody was talking about if I can't sneak it into a brief because I'm not allowed to, or because of page limitations, well, then maybe you're the person who carries a good old fashioned foam core board of a graphic or a document or a photo that's key in the case to your next hearing, right?
Yeah,
So
Charli,
that
they
if your
stay up.
judge
I
is
can't,
interested, you
they
plop
stay
it
up.
up on the table and you say, well,
It's
hey,
really
I think this
important.
is responsive to your question, Judge. And so now you're not really trying to figure out where do I shove it into a pleading or into a brief, but this judge has been curious in real time about my case. I remember working very early on with a lawyer who had a big motion in limine hearing, and this was a case about competitive pricing among hotels. And our kind of funny little client had this way of saying 49, 69, 89. And he was talking about the 3 different levels of pricings for rooms at a hotel. But he just kept saying it all comes down to 49, 69, 89. And so we just put that on a poster and we carried it with us to the motions and limine hearing. And the judge, I mean, this was central to the case. And every time it came up, the lawyer just picked up the poster and said to the judge, 49, 69, 89, judge. And the
Charli,
judge started saying it. The judge started saying
yeah,
it all comes down to
it's
49. So
it's
be
overlooked. It's
creative. Yeah.
overlooked during these things because the
And
screens come
by
and
the
go.
way, that was I mean, the process of getting someone to create that poster that they carried into the hearing, it might have cost $100. I'm really serious about that. So Suann and I are not here to, sell you on graphic design for the $4 billion cases. We see these things working day to day in every type of case through
Pen to
every
paper.
part of the trial. That's right. And I think we're reaching close to the end of our time. So should we invite Michelle in to wrap us up?
Yeah.
Here I am.
Hi.
Ta-da! Okay, here comes your bonus poll for sticking with us through the Q&A. The question is, this CLE is great. How can I access more great CLE programs? And your answer options are log in to trialacademy.org, navigate to our on-demand library under education. You can search by credit type, topic, course title, or presenter. Charli has presented for us before. You can throw her name in there and find a past presentation if you are interested. It is free for Academy members, $75 a course for non-members, and that is why you should just join. So
Michelle, don't
what?
turn us off before you give
I
us the
won't.
chance to say, because this is my second time back.
Yeah,
There's
yeah.
really never been anything like this that comes at such an easy opportunity for both presenters and your members alike to sit down and have a great conversation like we did. I mean, your audience members are engaged, they're interested, they ask good questions, they give speakers an opportunity to say more than we prepared to say. And I can't say enough about how efficiently and effectively you are delivering great CLE content. And Suann and I, and Bob too, have done a lot of CLE work in our careers. And I think you've really figured something out here.
Oh, thanks. Yeah, we have the best. We have the best attendees and we have the best presenters. I'm very, very lucky. This is not a bad gig I have going here.
Yeah, take me to Spain next time. Sign me up.
I know. Academy members, you can come with me. CLE abroad. We just did Spain. Next is the Nordics, Finland, Norway, Sweden. If you ever wanted to learn stuff about Vikings, my husband's super excited about the Viking situation. And that's in September. And then we have Morocco in January, which is such a cool place to be. If you've never been, you got to sign up for that one. And then we're also doing Sicily in April.
Sounds good.
That's the plan. All right. If anyone has any questions, info@trialacademy.org is the best place to direct your questions. If you want to get in touch with Suann or Charli, we can also put you in touch with them. And if you need anything, or you want to join and become a member, or if you're freaking out about CLUs for some reason, feel free to email us and we will help you out. Thanks so much, everybody.
Thank you,
Thanks for being
Michelle.
with us.
Thank you, Michelle.
And
Thanks for
so
connecting
much.
us, Charli. Okay.
Great to
Awesome.
see
Bye,
you.
everybody.
Bye.
Thanks.